You're watching
नमस्कार. आयच्या ग्राउंड झिरोक तुमकां सगळ्यांक येवकार. आयचो विशय जो आसा जाचेर म्हाका दिसता गोंयभर ऑलरेडी भयंकर वाद सुरू जाला आणि जे सरकारान केला ते कित्याक केला, हाजे फाटलो हेतू कितें आणि हाजो फायदो कोणाक, हो प्रश्न म्हाका दिसता आज प्रत्येक गोंयकारांच्या मनात आसा. आमी उलयतात सरकारान विधानसभेत पास केल्ल्या भूमिपुत्र बिला विशीं. त्या बिलाचे नाव धरून त्या बिलाचे कंटेंट्स मेरेन सगळ्यो गजाली सद्याक वादग्रस्त थारल्यात. एक एक करून ह्या मुद्द्याचेर आमी आज उजवाड घालतात आणि म्हाका स्टुडियो भितर आज जॉइन जातात गोंयांतले नामनेचे राजकीय विश्लेशक, आदवोगाद, कायद्याचे अभ्यासक आणि जे ह्या बिलाची विस्कटावणी करतले एडव.क्लिओफातो आल्मेदा कुतिन्हो. क्लिओफातो बाब, वेलकम. सगळ्यात पहिली गजाल, तुम्ही जेन्ना हें बिल वाचलां तातूंतले प्रोविजन्स पळयल्यात, तुमचो फर्स्ट इम्प्रेशन कितें?
First impression is that it is a election stunt, it is a fraud on law and joke on the poor people, especially migrants. It's a joke, absolute joke, simply because the government also knows that this law will not stand the scrutiny of the courts. We get an impression that the government is trying to regularize encroachers. According to me, no. Even people who are occupying houses as tenants, people who are occupying houses as live-in license holders, all those people would be within the sweep of this law, and they would be in a position to take advantage of this law. Secondly, if you look at the law, the water connection, electricity connection or the house number need not be in the name of the person who is claiming to be there. Even if the water connection, electricity connection, house tax is in the name of the owner of the house, the person who is occupying it in April 2019 will be in a position to take advantage. I would say a tenant, a rent-paying tenant, can now say, grant me ownership of 250 square meters of land. This is something unheard of anywhere in the country, anywhere in the world.
दोन मुद्द्यात आता वन बाय वन आमी स्टार्ट करूया. पयली म्हळ्यार जो वाद जाला भूमिपुत्र ह्याचेर, एंड दॅट प्रोविजन ऑफ 30 years ऑफ डॉमिसाइल सर्टिफिकेट. हाऊ डू यू लुक एट दॅट प्रोविजन?
I look at it, see, Bhumiputra could be son of the soil, and I would say a person would be Bhumiputra if he has been here for 2-3 generations to get some sort of a status of, person of Goan origin. Now, a person of Goan origin could be a person who is there for 3 generations back, but this Bhumiputra is totally misleading. Firstly, it talks of 30 years, but that 30 years has nothing to do with the structure. You may be residing in Goa for 30 years, but you can claim ownership of the structure if you have entered that structure in April 2019. So that is why I am saying that the word
हो मुद्दो खूप इम्पॉर्टंट असा जो दोतोर सांगतात ते की तुम्ही 30 वर्षां त्या घरात रावला हाची गरज ना.
एप्रिल आयल्या पुरो, एप्रिल 2019 आयल्या पुरो.
ही गजाल म्हाका दिसता लक्षात घेयात हाऊ बॅडली दिस लॉ इज ड्राफ्टेड. की तुम्ही 30 वर्षां एक घरात रावतात हाची गरज ना. तुम्ही 30 वर्ष गोंया खंयी रावले आता, तुम्ही एप्रिल 2019 मेरेन जर त्या घरात रावतात कितल्याय काळा खातीर, 1 वर्सा खातीर, बरोबर न्ही दोतोर? 1 वर्सा खातीर, 2 वर्सां खातीर, कितल्याय वर्सां खातीर, यू कम विदिन द एम्बिट ऑफ दिस लॉ.
Correct. And again I am repeating, the house tax, water and electricity need not be in the name of the person who is claiming the right to the house.
एक गजाल आमी फायनर विस्कटावणी मागीर करूया. दुसरो जो मुद्दो येता तो म्हळ्यार 250 स्क्वेअर मिटर. म्हाका दिसता गोंया भितर एटलीस्ट 95% लोकांची घरां 250 स्क्वेअर मिटर आसची ना आणि 95% ऑफ द पीपल इन गोवा आय डोंट थिंक एनीबडी स्टे 250 स्क्वेअर मिटर हाऊस. सो प्रश्न पडटा की जर बारीक मनशा खातीर केला जाल्यार हे 250 स्क्वेअर मिटर प्रकरण कितें? तुमकां कितें दिसता?
Even under the Munkar law, in city, the Munkar is entitled for 200 square meters. And here, it is 250 square meters. So somehow, according to me, the government also knows that this law is humbug. They know that it is humbug, but somehow...
You are saying no government can pass this law without knowing that?
Yes, one. Number two, anyway, today is Movin's birthday. So maybe they wanted to gift him this bill so that he can have his birthday celebrations very well. And maybe today he has his birthday very well. I don't think that it can reach anywhere.
You are saying there is no rationale for this 250 square meters?
There is absolutely nothing. See, and if you are telling me that they want to help people who live, say, in small structures, there will not be 250 meters available.
Correct.
And maybe this will only lead to a big land grabbing. Say, in so many of our villages we find that some landlord, some owner has built, say, 2-3 houses, then they give on rent. Now each of this house, each of this room is entitled to be claimed under this law, and each of this person will now claim 250 square meters.
दुसरो जो प्रश्न येता तो म्हळ्यार this law coming in direct conflict with the existing laws. त्या गजाली कडेन कशें पळयता तुमी?
See, they are having something called a overriding effect. But I would say it cannot stand the scrutiny of courts, because in 2017 such a law brought in Maharashtra was struck down by the division bench of the Bombay High Court. It went to the Supreme Court. It was a judgment of Justice Oka, and the Supreme Court also upheld that law. But to my mind, this law is much worse than the Maharashtra law, because here it is giving ownership of houses where you have just occupied. There is no regulation at all. I can understand there is some semblance that the house tax stands in your name.
Yeah.
The electricity connection is in your name.
And I think
even that is not there.
You cannot challenge this in the court of law.
What is that?
If once it comes before the authority, and once the authority gives its verdict, can this be challenged by an individual landowner?
Certainly, the law itself, according to me, the law itself will come under challenge. The constitutionality of this law, that is, it could be challenged, say, under Article 14, Article maybe 21. Of course, fundamental right to property is not there anymore. But 14, but such laws are routinely struck down by the courts. I would say number of matters are pending before the Supreme Court from various states, where so many directions are given to the states not to have such laws, and the states have to give compliance reports in respect of such laws, such regulations, where the Supreme Court in number of matters has come down heavily on such regularization.
एक हा क्लियोफाटो तुम्ही म्हणता ओव्हररायडिंग इफेक्ट. वो ओव्हररायडिंग इफेक्ट कितें? फॉर एक्झाम्पल हांव लोकांक एक्झाम्पल दिवन कित्याक सांगता, सो दॅट कायदो तितली किचकटसाणीचो ना हो. सादो कायदो केला, पण तो इतलो भयानक केला की हजारांनी गोंयकारांची तकलेक ताप आनी कोणाचो प्रश्नूय सुटचो ना. म्हाका एक गजाल सांगात, जेन्ना तुम्ही ओव्हररायडिंग इफेक्ट म्हणटात, समजा एका मनशाची एक जमीन आसा, थंय येवन कोणी तरी एनक्रोच करून एक घर बांदलंय, तो मनीस समजा तुम्ही खंय तरी भायर आसता, आज जर त्या मनशान सांगले की आपल्याकडे पैसे आहात, हांव पैसे दिता, मार्केट रेटीन हो जागो घेता आणि हे जागो आपल्यालो, सो ह्या कायद्याप्रमाणे तुम्ही म्हणतात की तो जागो त्या मनशाचो जाता. सो व्हॉट इज द सॅंक्टिटी ऑफ द टायटल दॅट द पर्सन हॅज?
See, the person
What
has,
happens to the sanctity of the title?
The person has ownership to the land. One. Meantime, you are disturbing the Panchayat Raj Act because you require a Panchayat license. You are disturbing Town and Country Planning Act. You are disturbing every other law, say Land Revenue Code for conversion. Every other law is violated. So this law tries to override all those laws. And according to me, such overriding is not permissible at law. See, in 2016, they brought one such law which spoke about regularization of unauthorized construction, where planning authorities license was not there, conversion was not there, and those type of things were sought to be regularized. Up to now, can you tell me how many houses have been regularized? From 26, now 5 years have passed.
Correct.
Hardly anything. Now that law was similar, and according to me this is worse.
या सो एक गजाल जी येता ती म्हळ्यार तुम्ही म्हणटात की त्या टायटलाची सँक्टिटीज हो कायदो काडून उडयता.
Correct. See, and I will go a bit further. See, we in Goa have the Munkar law. It sought to protect Munkars who are residing in the property of the Bhatkar in 76. Those cases are still pending before various authorities. We have the Agricultural Tenancy Act, where ownership was sought to be given to the tiller. Now, those laws, we would say, were laws which tried to help a section of society,
Correct.
which were downtrodden.
Correct.
But
Justifiably.
here,
Absolutely
yes,
justifiably.
yes. Here, I am saying you are putting a premium on illegality. A direct premium on illegality.
And not only आता हो विषय आयलो म्हणजे म्हाका आय एम क्युरियस आनी म्हाका दिसता लोकांक तुमी विस्कटावणी करून सांगची. कूड मुणकार कायदो एग्रीकल्चर टेनन्सी एक्ट फंडामेंटल्स आर सेम बट द ड्राफ्टिंग इज डिजास्टर्स एज फार एज द रिसेंट लॉ इज कंसर्न. हाउ these two things are different?
Okay.
Yeah.
See, Munkar law and the Agricultural Tenancy Act were both struck down by our High Court. Both laws were struck down. They are in force only because they have been placed in the 9th schedule of the Constitution of India. Both Munkar law and Agricultural Tenancy Act have been placed in 9th schedule, and that is why they have been protected. This law does not have that protection. This law may get a protection only if, say, the Parliament places it in the 9th schedule. Otherwise, it does not have that protection.
So that is one. But fundamentally, conceptually, principally, how these two acts are different? What was right in Kul Munkar Act, which is wrong here?
See, in
terms of safeguards, in terms of even pure drafting of the law.
See, there the person Munkar Kaida Podaya, there the person was residing with a fixed habitation.
Correct.
So थंयच रावतालो आनी कितल्या वर्सां रावतालो. He was residing on a particular date.
Yeah.
तेका आनी घर नाशिल्लें. Here it is not required that तुका आनी घर आसा आनी I mean that requirement is not there. You may have two houses. Where is the
and
thing?
you may just go and build a third one.
Yes, you may build a third one.
Yeah.
So fixed habitation was a concept in the Munkar law which is not there here. You are just entering here in April 2019 and you are claiming a ownership to this house, which is absolutely, I would say, a joke on the law. It's a fraud on the law. And also there is another aspect to this law. See, laws are to be passed by discussion and debate. This law was given to the MLAs at 4 o'clock in the morning and it is sought to be passed that very day. Without any discussion, without any debate. How it is possible? Firstly, such laws require 48 hours notice.
Yeah.
Now 48 hours notice is not there. There is no discussion, there is no debate. Even there is no discussion and no debate amongst the people. The Chief Minister told us, the Revenue Minister, Movin Gudino told us that there is a law coming on the Panchayat side to give house tax,
Yeah.
house number.
Yeah.
And suddenly this law is brought. I am saying that some discussion has to be there on any law, whether in the house, outside the house. That also has not happened.
आणि एक दोन गजाली ह्या कायद्याच्यो ते नंबर 1 इज मार्केट रेटीन हे घेवपाचे. सो दोन प्रश्न आहात. मार्केट रेट म्हणटना नक्की रेट खंयची जी गव्हर्नमेंटान स्पेसिफायड केल्या ती काय एक्चुअली जी मार्केटाक चलतात
ना, they have said-
आणि दुसरो सो even if I don't want to sell my piece of land, does this law force me to sell my piece of land?
Yes, the market rate
Yeah.
is what the government has notified for stamp duty. One. Number two, now even if the government acquires land, it is 2 times, 3 times the market rate. But that is not the case here. And it is only as per the Stamp Act. And secondly, it forces the owner to sell. It is almost like acquisition.
So the owner of the land does not have a choice.
Under the law, no.
Yeah,
The authority will decide whether it should be within
It should be sold or not.
Yes. Now I have another angle to this law. See, they say a dwelling unit means a permanent structure having a plinth not exceeding 250 square meters. Will a flat apartment come within this sweep or not? See, can you say that I am occupying a flat, I was occupying a flat on April 2019, please grant me ownership of this flat? Why should somebody not contend so? Anything and everything. I would say the law is also badly drafted.
Yeah.
To what is the target, whom do you want to accommodate, that also is not clear. I can understand now, since you have asked me about Kud Munkar. See, you had say there were people in the tribal belt, say in Kotigaon, Gaundogri, in Satari, people who have houses in government property.
Yeah.
If you wanted to accommodate them, then I would say it is tolerable, because finally they are residing there. They could be considered the real Bhumiputras who require their rights to residence
And
to
who
be
also
settled once and for
require
all.
concession from the government.
Correct, because finally it is government land.
Correct.
In forest is government land.
Yeah.
It's okay. But when you are trying to give private land to them, there has to be some
Sanctity of the title that
correct,
a
is
person
one.
is holding.
See, finally, even at law, if I want to throw out somebody,
Yeah.
he should be residing in my property for 12 years.
Yeah.
For after 12 years, if he is forcibly residing there, I may not be in a position to throw him out if he claims something called adverse possession.
Yeah.
But even that is not that 12 years. You are bringing a law in 2021 saying that in April 2019, if he was there,
Yeah.
he is entitled to claim
Ownership.
Ownership.
Yeah. And
So-
you are forced to sell your piece of land.
I would say this is just an election stunt.
Okay,
and
we'll come to that.
possibly
We'll come to
possibly
that
a
election
birthday
stunt,
gift.
Cleofato,
Birthday gift.
because this is a very interesting question, because you mentioned election stunt 2-3 times.
Yes.
This is a very.
No,
this
no,
law
I'm-
says that within 6 months
Yes.
from the date of new legislation comes into force, Bhumiputra may apply to Bhumiputra Adhikarini in such manner and such form as prescribed, along with such documents to prove that the dwelling unit has been constructed or has been in existence prior to April 1, 2019.
Yes.
आता ह्या 6 महिने कित्या खातीर आता जशी म्हाका ते 150 स्क्वेअर मिटर कित्या खातीर ते कळना आशिल्लें
Yeah.
तर ह्या 6 महिने कित्या खातीर
No, there is no rationale. See, even in the 2019 law, they have-
suppose this has been done with a absolute genuinity,
Yeah.
जाल्यार 6 महिने कित्या खातीर
correct. See, 6 months, because they know people will take 6 months to apply,
हय
and meantime elections will come.
meantime people will take another 2-3 days to vote.
Yes. Meantime elections will come, and this law will be forgotten. I only hope the opposition at least comes together and tells us that we will not implement this law, or at all, even if the governor signs this law, we will repeal this law in the first session next time in case we come to power.
किंवा खूप बरी विस्कटावणी. म्हाका लास्ट एक गजाल विचारपाक, ज्या मुद्दो तुमी मातसो टच केलो पण म्हाका दिसता ताजेर खूप गंभीरपणान चर्चा जावप गरजेची, लोकां भितरय जावप गरजेची, मिडिया भितरय जावप गरजेची. आनी तो मुद्दो म्हळ्यार ज्या तरेन हे फाटले 3 दिसाचे सेशन जालें तें फांतोडेर 4 मेरेन असेंब्ली चलोवप, जेन्ना सेशन चड दिसाची घेवपा जाता, बजेट डिस्कशन करनासतना पास करप, आनी मागीर ही इतली म्हत्वाची बिलां जांचो गोंयच्या जनतेचेर हाजे सामकी दुर्गामी परिणाम आसात, लॉंग टर्म इम्पॅक्ट आसा. एज अ सिटीजन, एज अ लॉयर, एज अ पॉलिटिकल एनालिस्ट, ज्या तरेन हें सेशन जालें What do you want to say?
See, firstly, they are using the pandemic to cut short the session. When almost everything is open, I do not see why the session should be only for 3 days. See, bars are open, restaurants are open, and now they said up to 11 o'clock they can be open. All shops are open, everything is open. So why should the assembly only be for 3 days? And this habit of bringing laws last minute, without giving notice, without having discussion, is absolutely undemocratic. See, every law must be scrutinized. Particularly law of this nature must have gone to the select committee. There are various committees. Each of the committee must scrutinize these laws, show the strong points of these laws, bring out the weaknesses of these laws, see how these laws could be modified, and then only bring those laws. Last time, one day earlier, they passed 9 bills, and on the last day, 11 bills were brought. Notice of 11 bills is given at 4 o'clock in the morning.
What about the budget being passed without discussion?
See, as far as the budget being passed without discussion, it is again the same situation. The same situation because they suspend rules and pass the budget. See, assembly is a place where questions are asked. Budget is the time where there is discussion on every other department. How the departments function is discussed at budget time. If you do not get any opportunity, your opportunity is at the time of budget discussion. So that is not there. So the government actually, according to me, is unable to face the house. And because they are not in a position to face the house, because, see, 2 things have happened. One is they are not able to face the house. They also lack talent in answering questions. And that is the reason I see that they are roughshoding over the house, because they have a majority. And the majority is used to bulldoze every possible
I think very important pertinent points. हांव लोकांक एकच गजाल सांगता की खंयचोय कायदो जेन्ना पास करता तेन्ना बेसिक गजाल आमी इतलेच समजतात की सरकारान हाजेर कितें तरी अभ्यास केला आसतलो, कितें तरी डेटा पळयलो आसतलो, कोणी तरी सरकारा कडेन ह्या बाबतीत निवेदन दिलं आसतलें, ते निवेदन दितना एक स्ट्रॉंग कितें बॅकिंग लॉजिकल आर्ग्युमेंट किंवा लॉजिकल डेटा दिला आसतलो. आयच्या घडयेक जेन्ना सगळ्याक हो प्रश्न पडला, सगळ्या गोंयकाराक हो प्रश्न पडला की हे भूमिपुत्र बिल जाचें नांव धरून कंटेंट्स मेरेन सगळ्या गजालीचेर वाद चल्ला, ते कित्याक हाडलं का म्हणून. एक गजाल सामकी सरकारा कडेन आमी मागतात, ज्या डेटाच्या आधाराचेर कितें तरी डेटा केला आसतलो की हो कायदो हाडल्यार कितली लोकांक कितली घरांक फायदो जाता, ह्यो गजाली पळयल्या आसतल्यो. हो डेटा जनते मुखार दवरात, हो डेटा लोकां मुखार दवरात. ना जाल्यार तुमी कांयच अभ्यास केलो ना, खंय तरी एक कडेन घुडा भितर बसले आनी एक कायदो ड्राफ्ट केलो हें तरी मान्य करात. कारण जेन्ना असो कायदो तुमी ड्राफ्ट करतात जाचेर गोंयच्या लोकांचेर, गोंयच्या बाकीच्या कायद्यांचेर जे इतली वर्सां तयार जायत आयल्यात त्या सगळ्यांचेर जाचो परिणाम जाता, तेन्ना तुमचें कर्तव्य की ज्या डेटाच्या आधाराचेर, ज्या लॉजिकाच्या आधाराचेर तुम्ही हो कायदो फ्रेम केला ते लोकां मुखार दवरचें. सो लोकांकय कळूं दी की हो कायदो जर अस्तित्वात येता आनी जर गोंयकार भूमिपुत्र जर हाजो फायदो घेता जाल्यार कितल्या लोकांक फायदो जातलो, कितली बेकायदेशीर घरां कायदेशीर जातली, तातूंतली कितली गोंयकारांची आसतली, कितली स्क्वेअर मिटर आसतली, कितली गोंयच्या भायल्या लोकांची आसतली, कितली प्रायव्हेट जमनीवेली आसतली, कितली सरकाराची जमनीवेली आसतली, कितली कॉम्युनिटीची जमनीवेली आसतली. म्हाका दिसता हाची बेसिक अभ्यास तरी हो कायदो हाडचे पयलीं सरकारान केल्लो आसतलो. इतले आमी कायदो हाडला म्हणून मानून चलतात. सो तो डेटा जो आसा तो कृपा करून जनते मुखार दवरात, सो दॅट आमकांय कळूं दी की खरेंच हो कायदो करतना तकली उजार जाल्या काय कितें जाला तें. हांव इतल्याचेर थांबता. क्लिओफात बाब, थँक्स अ लॉट फॉर जॉयनिंग अस इन द स्टुडिओ आनी इतली बरे तरेन विस्कटावणी केली. पळयत रावात प्रुडंट. नमस्कार.